Chair. Mr. Chair.
I call Stuart Nash.
Thank you very much, Mr. Chair. Mr. Chair, there are 3 points I want to make, and I want to start with part 3. This is miscellaneous matters regulations. In section 49, it says that the Governor-General may, by order of Council, make regulations for any of the following purposes. And part C of this is prescribing details relating to the administration of the register, and part D talks about circumstances in which information will be required concerning the identity of the registrable offender. The reason I have some concerns about this, Mr. Chair, is what this part 3 basically says is if the minister or the government of the day doesn't like how this is operating, they can change the rules without bringing the bill back to the House. And I think from a constitutional perspective, that is quite dangerous, because what we're talking about here is something, as a number of members have talked about, quite subjective in the nature of law we're proposing and the type of matter we're proposing here. And I think by taking it out of Parliament and putting it into regulations, we run the risk of actually, of that separation of power. I would have actually liked to see any changes in this come back to the House as a remedial bill or as an amendment bill. Mr. Chair, there's just one other thing I'd like to just query the Minister on. She talked about section 43, where the Commissioner may disclose information. The reason I have concerns about this is that word may, because this doesn't put any obligation whatsoever on the Commissioner to disclose information to anyone at all. It's purely subjective, and what it says, and I'll quote this, Mr. Chair, 43(1), the Commissioner may disclose personal information in the register to an affected person if the Commissioner believes on reasonable grounds that the registrable offender poses a threat to life, welfare or sexual safety of a particular child or particular children, end quote. Now, Mr. Chair, there are 3 subjective terms in that which cause me concern. The first one is that the Commissioner may disclose personal information. The second one, on reasonable grounds, and I'm not too sure what constitutes reasonable grounds. And the third one is the welfare of a particular child. Now, whether welfare is obviously we know about the physical and or sexual well-being because that's highly documented in the case, but the mental and the psychological well-being is again subjective, and I think this clause here around when the Commissioner may disclose information or the information that can be disclosed is too wide and is open to interpretation. And the last thing we want to see is someone come before the courts because they've caused harm to a child, and the Commissioner was held up as saying the Commissioner should have provided this information, but he didn't. And therefore we go through debate around what is reasonable information and when it should have been released. But Mr. Chair, what I would like to talk about is actually what the personal information must be recorded, i.e. what this register is. So we're talking about section 15 here. So what happens, Mr. Chair, is there are 22 pieces of data that must be recorded within 72 hours, and that's clause 16, 72 hours of the offender being released from custody or made subject to a registration order. Now, these are quite specific, and I applaud that. The concern I have, Mr. Chair, is that if we make an assumption, and we've heard these figures, that there are 256 offenders released from prison every year. After 10 years, this is 2,500 sex offenders. And it specifies in the bill, Mr. Chair, that an offender must update the report at least once a year or as designated by the Commissioner. So that's 55,000 pieces of data that have to be monitored every year, minimum, after 5 years. And I suppose the thing that's an average of 7 per day. But what it does say in the bill is actually, in some cases, the person has to be monitored for their whole life. So what concerns me is the level of resource that is going to go into monitoring that 55,000 pieces of data every year, and conceivably even more as this builds. And because what we must ensure in the public service is that when we collect data, it is there for a purpose and not simply for the fact of data collection, if you know what I mean. Yeah, thank you. Mr. Speaker, the thing about this also is when we look at the section 37, it outlines the penalties for not disclosing information. So it's $2,000 for failure to find information, to disclose information. And this is based on the reasonable person test again, but $2,000 really isn't a great fine But the thing is it is quite prescriptive in here, Mr. Chair.
Pamji, Pama.
Thank you, Mr. Chair, for the opportunity. Mr. Chair, I would like to speak to